Welcome back to our YouTube channel. Today we'll be talking about legally recognizable grounds for divorce in Nigeria. Marriage is a beautiful thing, but of course there are some things that happen in that union that makes parties to begin to reconsider their marriage. Now, marriage in Nigeria is governed by the Matrimonial Causes Act, and the procedure in court if you want to dissolve your marriage is governed by the matrimonial causes rules. These are pretty old acts because the act is a 1970 act and the rules is a 1983 act rules, yeah, but it's still very much applicable. Now, the act stipulates that a marriage under 2 years cannot be dissolved. So if you're married within 2 years, you cannot be dissolved. You have to go and look for a way to enjoy your marriage. This is called the 2-year rule provided for under Section 30 of the Act, which states that subject to this section, proceedings for a decree of dissolution of marriage shall not be instituted within 2 years after the date of the marriage, except by the leave of court, except by the permission of the court. So in that, what that means is that in order to institute a petition for a marriage less than 2 years, the permission of the court must be first sought and obtained by an ex parte motion alongside the petition for divorce. All right. Now, generally there are grounds for dissolution. So you don't just wake up and say, oh, you want to dissolve your marriage. There are laid down procedures and there are grounds set out under the law, under the Matrimonial Causes Act. So we'll tell you what those grounds are. So if anybody is intending or looking at divorcing their spouse, you must ensure your reason comes under one of these grounds. All right. Now, these grounds are set out under Section 15, sub 2 of the Matrimonial Causes Act. We are setting out the section because you can also decide to refer to it during your spare time. Now, the first ground for dissolution of marriage is that the respondent, that is the person you want to divorce, has willingly and persistently refused to consummate the marriage. You know what that means is the person has refused to have sexual relationship with you. So for that ground, for that reason, you can dissolve your marriage. Okay. So where the petitioner must prove that the respondent has failed to have sexual intercourse with him or her, or where it is proved that sex occurred even once, the marriage will be deemed consummated, and therefore the petitioner cannot rely on this ground. So if it happened, if it's not a case of he rarely allows it happen, it's a case of it hasn't happened at all. Okay, so that's a ground. That would be a ground for divorce. But if it has happened before, maybe once, twice, and it doesn't happen often, that shouldn't be a ground. You have to look for another ground. The second ground is that since the marriage, the respondent here, whenever I use respondent, it means the other person, the person you want to divorce. That since the marriage, the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent. Okay, so for this ground to hold water in court, the petitioner must prove that not only does the other party commit adultery, but he or she finds it unbearable to live with such infidelity. Some persons can put up with adultery. So if your spouse commits adultery, it's a ground for divorce. You must also show that it's now unbearable. You can't live with that kind of person anymore. All right, it's unbearable for you. Then the third one is that since the marriage, the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. This can be cases of domestic violence. So he has acted in such a way that a reasonable person would not be expected to live with him. Then maybe someone who's extremely a drunk or a cultist, a ritualist, or kind of thing, you get to discover. Then the other one is that the respondent has deserted the petitioner for a continuous period of at least 1 year immediately preceding the presentation of the petition. So if the person you want to divorce has left the house for you for about 1 year before you present the petition, is a ground. Then also that the parties to the marriage have lived apart continuously for a period of 2 years immediately preceding the presentation of the petition. So if both of you have lived apart for a period of 2 years. So this does not this does not object to the decree of dissolution being granted. All right. So basically, what that means is that if you have lived apart for 2 years, you can just come for no reason. That reason is enough. The person doesn't have to commit adultery or anything. Okay, but just show that you have stayed apart for 2 years. Then the other one, that the parties to the marriage have lived apart for a continuous period of 3 years immediately preceding the petition. This is another ground. Then also that the other party to the marriage has for a period not less than 1 year failed to comply with the decree of restitution of conjugal rights. So if the court has ordered that they haven't been in sexual relationship, the court ordered him to resume sexual relationship and he has refused for a period of 1 year, then it's a ground for divorce. Then lastly, that the other party to the marriage has been absent from the petitioner for such a time and in such circumstances has to provide reasonable grounds to presume that he or she is dead. Generally 7 years. So if you can't find your spouse for a long time, let's say 7 years, 8 years, you can presume that the person is dead and then you file for divorce. All right. A petition for dissolution of marriage can be presented on these grounds. All right. Of course, you can reach out to your lawyer to do that for you. Please subscribe, like, and comment. Thank you.